This is Michael Popok, Legal AF After Dark. On the most recent episode of Legal AF, Ben Meiselas and me debated the testimony of Don Jr. and other witnesses for Donald Trump, the fools that they're making of themselves, the fact that they're not doing a darn thing to turn the case back in their favor, the civil fraud case brought by the New York Attorney General, and our predictions of where this case is heading. Take a listen to our most recent clip.
A not so tough decision had to be made by Judge Engoron. You see those smooth transitions right there in denying Donald Trump's mistrial motion in New York. The mistrial motion filed by Trump basically just attacked the judge's principal law clerk, and also just very oddly, 3 pages were just photographs of the law clerk, because at that time there was a gag order imposed. So by putting it in the actual filing itself, they were able to then show, what she looks like and show the photo. And the gag order's now been temporarily lifted by the appellate division. I want to hear your take on that, Popok. And also, we started the week, it feels like a year ago, but with Don Jr. testifying. And you and I, on the last Legal AF, we were like, what is Don Jr. even going to testify to? Because when he was called by the prosecution in this fraudulent valuation civil case, he said that he didn't have any experience with the statement of financial conditions, didn't review them, doesn't know what they say. So there was no foundation that he has any understanding of the underlying financials to the business. And again, when people try to maga-splain to me, this is the way powerful businesses run. No, the people who lead businesses know their financial numbers. Okay, they all do. You don't have a situation where you call the head of IBM or Apple or a so-called big corporation and you say to them, hey, do you know your statement of financial conditions? They go, no, I don't look at those. Hey, do you realize that you're even the CEO of the company? No, I don't remember I signed that. I sign a lot of documents. I mean, come on, that's ridiculous and pathetic. But so we were like, what is Don Jr. going to actually testify to? And by the way, let me be very clear. The Trump Organization is a small family-held entity that is far not even near the size that it tries to ever project. What's Don Jr. going to testify to? Well, they showed Don Jr. a pre-planned PowerPoint presentation that was never even produced during discovery. And so the prosecution objected to it. They're like, what? What are you showing them? A PowerPoint? This hasn't been produced. This is not the way trials work. You don't just show PowerPoint presentations. So they objected. The judge let it happen, because I feel like the judge realized that Trump and Don Jr., they were just trying to bait him so they could play the victim and say, well, we didn't let the evidence in. And so even though it's not actually legitimate evidence, so the judge is like, whatever, I'm the trier of fact. It's not a jury trial. Show me how great the Trump Organization is. Show me. And then they proceeded to show this bizarre PowerPoint presentation that talked about the history of the Trump family. And it was just embarrassing to even see what was going on. But what I found interesting is you had things then they said, and 40 Wall Street, 73 stories, and it's 63 stories. Again, they have to inflate everything. And then there's an SEC debt offering form that says that it's 63 stories. It's not 73 stories. And here's the thing, Popok, I'm going to toss it to you to give us the full roundup of everything that went down in New York, from your take to Don Jr., to the mistrial motion being rejected, to the administrative stay of the gag order. I just want the facts. You know what I mean? Look, if Mar-a-Lago was a residential property, I can have an honest conversation with you and say, I could see it being $150 million to $250 million valuation. That's not $2.5 billion or $1.5 billion. That's ridiculous. But yeah, sure, you want to tell me it's $250 million? Fine. I'll accept that. But why is it $27 million? And then you're going to go, well, the judge who hates Trump did it. And then it's well, now you're treating me like an idiot. And that's how you should feel watching this. Stop it. Don't, that's not what happened. Donald Trump devalued the property to pay less property taxes. The reason it's $27 million is not because Judge Engoron divined it. It goes, I hereby decree that Mar-a-Lago shall be $27 million. No, Trump did. And the Trump organization, people who testified in this case, said they did. And they executed a deed decades ago that said it will forever be used as a club for commercial purposes so they could pay less taxes. They didn't pay property taxes on $250 million. They sure as heck didn't do it on $1.5 billion. That's why the valuation is what the valuation is. That doesn't mean the property's not impressive. I'm sure it's a beautiful property. It's by the water, all fine, but you don't have to commit fraud with it. Then it's the same thing with 40 Wall Street. I don't own a building that's 73 stories. I think it's probably pretty impressive if you have a building that's 63 stories. By the way, Trump doesn't own it. A German family does, and Trump has an arrangement with them, but still impressive. But then you say that it's 73 stories? I mean, that's ridiculous. You have a 10,000 square foot penthouse. I don't live in a 10,000 square foot penthouse. You don't live in a 10,000 square foot penthouse. That's still pretty big. But then you have to lie and say it's 30,000 square feet so you can be that greedy and then lie and take out extra benefits and then do that with all of your other properties. It's like, let's just exist in the world of objective reality. And we saw with Don Jr.'s testimony there that even when he was doing this ridiculous PowerPoint presentation, this is why I think the judge just was fine allowing it to happen. It was filled with all of these unnecessary, other than they lie about everything, inflating of the assets. So I don't know. I think that's important just to say that, though, because I'm craving the facts. I'm thirsty for the evidence here. And I just get so bothered when you have Alina Habba and this whole crew just treat the American public and the world like fools. It's ridiculous.
They're about to lose their buildings and money and businesses and ability to operate in New York. And the best that they can come up with is flailing in court, attacking a law clerk, attacking the judge, moving from multiple stays and mistrials, and putting on evidence that stretches back to 1900 with Grandpappy Trump. This is the best that you got. You and I practice law, Ben. We try cases. Your first witness out of the box is supposed to be your best witness. It's supposed to be the one, we call it recency, primacy and recency. You're supposed to put your best witness first, usually a roadmap witness. You put if you have 4 witnesses or 5 witnesses, whatever you got, you put another witness towards the end because that's the most recent thing the judge will remember. And sort of in the middle, you sandwich other ones that are okay. They're not doing well with any of them. They just put on an expert yesterday that in which he admitted that he did not look at any of the underlying representations of Donald Trump, considering about 40 Wall Street, the property that you just described so accurately, and basically disqualified himself as an expert to give the judge any relevant opinion about the issues that are at stake in the case. This untethered quality of this failure of the Trump people and the lawyers, because they're not very good and they don't have the facts or the law on their side, to connect the evidence and the testimony to the issues that are in front of Judge Engoron, and instead just want to sue the judge. They filed another lawsuit against the judge in his official capacity under what you and I described in September, Article 78 of the New York law, which is an action that you can bring to an appellate court to try to compel somebody to do something, in this case, the judge to stop gagging, or the judge to rule in their favor, or the judge to declare a mistrial, or whatever they want him to do. But if this is the best they got with Don Jr., and then I want to talk about procedure in a minute, then all hope is lost for them, because he had already, as you and I noted last week, disqualified himself, Don Jr. did, as a precipient witness with knowledge on the key issues in front of the judge, meaning the use of the statement of financial condition that's at issue in the case during the time period that's in the case, that's allowed in the case, and the relationship between, or the nexus between, the use of the statement of financial condition of Donald Trump, which we know has been cooked and artificially inflated, with banks, lenders, investors, buyers, places where he needed to get approvals, insurance companies, and other counterparties. That's the issue. And when when they decided in their little cutesy, smarmy fashion to get up on the stand one after the other to say, oh, that's not my job. Oh, no, I pour concrete. That was Eric Trump. No, I don't. Financial statements. I barely graduated from Wharton Business School. I don't know what that means. And Ivanka, I'm just a mother of a couple of small children down in Florida. I really don't know much about what's going on until we got into the old post office and that lit her up. And let me tell you all the details about the old post office. So that's their problem. They disqualified themselves in the case when they were dragged onto the witness stand by the attorney general in her case in chief. And now they can't now grow a brain and suddenly remember the things that they say they don't have any knowledge of. And to your point about, because you're right on it, this kind of mom and pop small organization thing, because Donald Trump never founded a major company where there were executives other than people with his own last name. I worked at a company, as people know, where I was the number 2 lawyer there. The CEO and the CFO, Chief Financial Officer, were 12 feet apart, right? One office sat between them because it's important that the CEO who's out there borrowing money, lending money, making deals and transactions, it has a close contact with the CFO about things like how much money do I have? What is my net worth? How's the company doing? Where are we with our lenders? And that is a constant interaction. But in the Trump organization, they sort of pulled the pin. That's because Daddy Trump didn't want. Have people looked at Alan Weisselberg? You think he was pushing back against Donald Trump, right? Speaking truth to power. You think McConney, that the controller, was speaking truth to power? Right? Nobody was. And that's not what Donald Trump wanted. He didn't want real upstanding officers and directors and control officers in his company. No. He wanted people that when he said, what's 2 + 2? And they said, what do you want it to be, boss? And he said 7. Great. We'll put you down for a 7. And the reality, as you outlined, Ben, and then I want to talk a little bit about New York procedure and what we just observed, is that Donald Trump was a billionaire, probably a single billionaire at all the relevant time periods. He just wasn't a 3 and 4 and 5 billionaire. And that's the problem for him, not for us. That was the problem for him, because in order to do the borrowing that he did at the rate that he did it and the volume that he did it, he needed to be over $2.5 billion or $3 billion in net worth. And that's what he told the counterparties. And that's why they did business with him. Those were requirements or conditions of their relationship, their financial relationship. But he wasn't there. So rather than go out and acquire and bring in investors and outside investors into his own company, he just changed the numbers, or had his people change the numbers to make him into a triple billionaire when he really wasn't. And so you have all of that going on. So when they can't put on any real evidence, the PowerPoint about Grandpappy Trump back in the 1900s building hotels / brothels in the Yukon for minors, that led to, one of my favorite moments so far in the trial is when the New York Attorney General objected and said, Your Honor, they're going back to the 1900s? Are they waiving the statute of limitations? Can we try them for crimes going back that far? And everybody sort of laughed. But the judge has a very clear sense of what his role is with no jury present in a trial that's going to stretch into 12 and 14 weeks. And he has to keep track of 50 or 60 witnesses, thousands and thousands in pages, maybe approaching 1 million of documents. And he does that, of course, with his law clerk. So now I'm going to turn to procedure for a minute. I practice in New York. Law clerks, newsflash, sit next to the judge. That's why the bench is built to have a desk next to the judge. Sometimes in different courthouses, depending upon their procedure, it's the bailiff, the law clerk, a clerk from law school that's clerking after graduation, or in this case, a lawyer who holds the role of principal law clerk. When the judge has a question about testimony, okay, they have transcripts that are being prepared each day, and it's up on their screen. It's an appropriate role, of course, for the law clerk to say what Don Jr. just said there is inconsistent with what Don Jr. just said 3 weeks ago at the beginning of the trial and handing a document to the judge to show him that. That's not her co-judging, which is what she's been accused of. That's her, as the case law and the ethics opinions outline, that's her serving a role like a close confidant or colleague within a law firm. When I got a question or I'm trying a case, let's say you and I, Ben, try a case together. Let's say it's your witness, but I'm assisting you, right? And you're doing your outline, and the witness hits on something that I know is inconsistent with a document or a prior testimony. It would be malpractice if I didn't run up to you at the podium and say, Ben, use this document. Use this one, right? That's not me co-litigating that witness with you. That's me doing an assist the way you would do it for me. And that's what we're watching. But to outsiders like Alina Habba, who doesn't practice in New York regularly, Chris Keiss is a Florida lawyer, and the other lawyer that sits on Long Island, and I don't think has been inside of this court much, everything is nefarious. Everything is, oh my God, there's whispering, there's note passing. She's co-judging. No, she's not. She's serving her role as principal law clerk. So they filed a couple of things last week, and then I'll turn it back to you. They filed an application with the a suit against the trial judge again under Article 78, and asked for a stay until the issue of the gag order and whether it was proper or not, the two gag orders and the two fines, could be decided by the full intermediary appellate court. It's not the highest level appellate court in New York. It's the second highest. And it sits in Manhattan, down on Madison Avenue, and it's the appellate division first department. I'm admitted in the first department. That's where I swore in 1992 when I became a lawyer. So that place had a quick hearing. One judge was assigned to it, David Friedman. Same judge. I'm not sure how that happened, because it should be done by spinning a wheel, and it shouldn't be done by being assigned to him. But he was the same judge who stayed the trial before the trial. There was they've been trying to stay this trial forever. Before it even started in October, they ran it in September to try to get the appellate court to stay the trial before it began. And this same justice, on his own, because he's allowed to do it, did an administrative temporary hold on the case. It didn't affect the case, because by the time the full appellate panel met 2 weeks later, the trial hadn't even started yet. And they, including that Judge Friedman, joining that full panel, ruled that there was not going to be a stay. Get going with your trial. And so this time, however, and I want to get your view on this one, the reporting from those that went into the room for the hour-long hearing at the first department suggests that Friedman had a very jaundiced view and was very skeptical of the New York Attorney General's position on the gag order. And he made two comments in particular that were reported. One is, well, the law clerk posted her own picture of her with Chuck Schumer at a fundraiser. And so it's good for the goose is good for the gander. They're allowed to comment on that and make it go viral. What's the problem with that? And very skeptical about gagging somebody who's running for president and not having him attack constantly staff of the judge, not the judge himself or the staff. So those were the two comments, and he put a pin in it because of the constitutional issues that are implicated. Now it goes to a full appellate panel, which he probably joins, and there'll be 5 of them, and there has to be a majority vote on this. What did you think about that? And then you and I can talk about the mistrial motion that's already been denied by Judge Engoron.
If you just were presented with the issue in a vacuum and said that Donald Trump posted a message of the judge's law clerk and a gag order was issued, and that's the issue that was presented, if you blinded your eyes and covered your ears to all of the context of Donald Trump's behavior, the stochastic terrorism, if you ignore context, I could actually see how an appellate judge who is presented with the issue says, well, why shouldn't you have a First Amendment right? If you want to post things, it's weird, but why is posting things about a judge's law clerk or a photo threatening or harassing? Well, it is when you understand the context. Donald Trump is trying to threaten and harass and attack her. You have to, and here's the thing, as it was presented on an emergency basis, Popok, versus a full briefing where all of the context will come out, you have in Donald Trump somebody who has been criminally indicted now 4 times. 4 times. Somebody who has threatened to execute military leaders. Somebody who is responsible for a judge, Judge Chutkan, for example, having her life threatened by the people who follow him. So the thing, and I go back to, we showed a videotape of this, of the Australian billionaire who's now a witness for special counsel Jack Smith, who it's alleged Donald Trump shared nuclear submarine secrets with. One of the things that he's on audio recording is saying about Donald Trump is that Donald Trump is, and the Australian billionaire right-wing guy basically says, Trump's really good at using enough ambiguity like a mobster, but not to actually say it. I don't think that makes you really good. I think that makes you cowardly and a crook and a freaking mobster who shouldn't be anywhere near the positions of power. But you have to understand it in its context of why it is threatening, why the behavior is harassing, and that's what you have to do. And the trial judge is uniquely positioned to do that. What I worry about is what I said before, though, is that an appellate division sitting in its ivory tower, insulated from the threats and attacks that are happening on a daily basis to that court. That court is getting inundated with death threats and attacks. It's easy for an appellate judge to be like, well, what's the big deal here? And that's what Donald Trump relies on, the way mafioso people rely on that. So that's how I think the gag order is absolutely appropriate. But I think that's where an appellate judge sitting in the ivory tower may say, well, no, what's the big deal? It's a photo. The big deal is that Donald Trump, in a misogynistic, targeted way, knows what he's doing, getting his people to try to destroy her life, to destroy the life of the judge, and not deal with the fact.
Well, there's an example of what we do only on the MeidasTouch Network on a podcast we call Legal AF, and the title is exactly what you think it is. It's every Wednesdays and Saturdays at 8 p.m. Eastern Time. I do it with my two co-anchors, Karen Friedman Agnifilo on Wednesdays, Ben Meiselas on Saturdays. If you know all about us, welcome back. If you don't know what I'm talking about, join Legal AF. You can get it on audio podcast platforms wherever you get your audio podcasts from. And if you know all about us, take that clip, send it off to friends and family and other followers, and get them to join the ride. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.